This is a reference proceeding before the High Court pursuant to Section 30 of the Court of Judicature Act 1964. The matter before this court is Public Prosecutor against Gun Bond Own and AINNUR. The constitutional question referred to this court is whether Section 122 Clause 1 of the Security Industry Act 1983 is inconsistent with Article 5 Clause 1 and 8 Clause 1 of Federal Constitution. The reference arises from proceeding in the Session Court where the accused were charged under the Security Industry Act 1983. At the close of prosecution case, the learned Session Court judge acquitted the accused on the principal charge. However, the accused were called to enter their defense on an alternative charge premised on Section 122 Clause 1. The accused subsequently raised a constitutional objection and the matter has been referred to this court for determination. Learned counsel for the applicant, you may proceed.
Much obligate, my lady. My lady, the application submit that Section 122 Clause 1 of the Securities Industry Act 1983 is unconstitutional as it violates Article 5 Clause 1 and 8 Clause 1 of the Federal Constitution. My lady, it is as well established that the Federal Constitution must be interpreted in a broad and liberal manner, particularly where the fundamental liberties are concerned. Article 5 Clause 1 guarantees that no person shall be deprived of life or personal liberty save in accordance with the law. The term law includes procedural fairness and fundamental principle of criminal justice. Among these principles are the presumption of innocence and the requirement that the prosecution must prove the guilt of the accused beyond reasonable doubt. However, Section 122 Clause 1 operates in a manner that is inconsistent with these principles. Under this provision, once a company commits an offence, every director or officer is deemed to have committed the offence unless he proves that the offence was committed without his consent or connivance and that he exercised due diligence to prevent its commission. My lady, the effect of this provision is that it imposes a legal burden on the accused to prove his innocence. This effectively removes the presumption of innocence and relieves the prosecution of its duty to prove essential of elements of the offence. As a result, a person may be convicted even where reasonable doubt exists. My lady, this provision is also overly broad as it applies to a wide class of a person, including director, officer, and employee. Such a wide application is unjustified and disproportionate. Further, my lady, the provision violates Article 8 Clause 1 of the Federal Constitution. In the present case, there were other directors within the company, yet only the accused were charged. This resulted in unequal treatment before the law. In light of the above, my lady, we respectfully submit that Section 122 Clause 1 is unconstitutional and ought to be declared null and void. Much obligate.
Much obligate, my lady. The public prosecutor submit that Section 122 Clause 1 of the Securities Industry Act 1983 is constitutional and valid. My lady, there's a strong presumption that laws enacted by Parliament are constitutional and the burden lies on the applicants to prove otherwise. Article 5 Clause 1 does not expressly provide for the presumption of innocence and therefore it cannot be said that the provision violates an express constitutional right. My lady, statutory presumptions are recognized in criminal law. In certain circumstances, the burden may shift to the accused, particularly where the relevant facts are within his knowledge. Further, a company can only act through its officers. It is therefore reasonable for the law to impose liability on the directors and officers when offence is committed by the company. My lady, the public prosecutor also has discretion under Article 145 Clause 3 of the Federal Constitution to determine whom to prosecute. Accordingly, the provision does not violate Article 8 Clause 1. In light of the above, my lady, we respectively submit that Section 122 Clause 1 is constitutional and the challenge should be dismissed. Much obliged.
Learned counsel for the applicant. This court would like clarification on your submission. You contend that Section 122 Clause 1 is unconstitutional as it reverses the burden of proof. Would you agree that statutory presumptions are, in principle, permissible in criminal law?
Much obliged, my lady. Yes, my lady. We accept that statutory presumption may be permissible in certain circumstances. However, we submit that the present provisions goes significantly further than a permissible presumption, as it imposes a legal burden on the accused to prove his innocence.
Counsel, could you elaborate on the distinction between an evidential burden and a legal burden?
Certainly, my lady. An evidential burden requires the accused merely to raise a reasonable doubt, whereas a legal burden requires the accused to affirmatively prove his innocence on a balance of probabilities. Section 122 Clause 1 imposes such a legal burden.
If that's so, would any provision imposing a legal burden be unconstitutional?
Not necessarily, my lady. However, where such a burden remove the presumption of innocence and permit conviction despite reasonable doubt, it becomes inconsistent with Article 5 Clause 1.
Land Deputy Public Prosecutor, how do you respond? Does this provision not create a risk of conviction without proof beyond reasonable doubt?
Much obliged, my lady. The accused retains the opportunity to rebut the presumption. The provision must view in the context of corporate regulation where such mechanisms are necessary.
But does this not effectively shift the burden of proof from the prosecution to the accused?
My lady, while the burden may shift, it is justified given the nature of the corporate offences and the knowledge possessed by the accused.
Counsel for the applicant, would you say the provision is disproportionate?
Yes, my lady. It is overly wide and applies regardless of the actual involvement, thereby imposing an unjust burden.
And in relation to Article 8, Clause 1, are you suggesting unequal treatment?
Indeed, my lady. Similarly situated directors were not charged, resulting into unequal treatment.
Very well. Okay. So, counsel for the applicant, you may reply.
Much obliged, my lady. My lady, the respondent's reliance on statutory presumption does not address the central issue, which is the extent of the burden imposed. Section 122 Clause 1 goes beyond a permissible presumption and imposes a legal burden requiring the accused to prove innocence. This undermines the presumption of innocence and the requirement of proof beyond reasonable doubt, my lady. Further, my lady, the justification of enforcement cannot override constitutional safeguard. This provision is overly broad and creates a real risk of injustice. Additionally, the unequal treatment of similarly situated individuals reinforces the violation of Article 8 Clause 1. Accordingly, my lady, we maintain that the provision is unconstitutional.
Counsel for the respondent?
Much obliged, my lady. My lady, the provision reflects a legitimate legislative response to corporate misconduct. It places responsibility on those in position of authority who are best placed to prevent such offences. The burden imposed is reasonable within its context. The provision does not automatically result in conviction, but also allows the accused to rebut liability. As for Article 8 Clause 1, prosecutorial discretion is recognized and the differential treatment alone does not render the provision unconstitutional. We respectfully submit that the provision remains valid.
Okay. Having carefully considered the submission of land counsel from the applicant and the land deputy public prosecutor, this court now deliver its decision. This reference raises important constitutional questions concerning the validity of Section 122 Clause 1 of the Security Industry Act 1983 in light of Article 5 Clause 1 and 8 Clause 1 of the Federal Constitution. So the court identifies several issues for determination. Firstly, whether the presumptions of innocence and the requirement that good must be proven beyond reasonable doubt form part of the fundamental liberties guaranteed under Article 5 Clause 1. Secondly, whether Section 122 Clause 1 abrogates or infringes those rights. And thirdly, whether such abrogation can be justified. Fourthly, whether the provision is reasonable and proportionate. And finally, whether the provision violates Article 8 Clause 1 of the Federal Constitution. So the court answer the first issue is the affirmative. The right to a fair trial is an integral component of Article 5 Clause 1. The term law must be interpreted to include procedural fairness and fundamental principle of a criminal justice. So among these principles are the presumptions of innocence and the requirement that the prosecution must prove guilt beyond reasonable doubt. So the court next consider the effect of Section 122 Clause 1. So this provision deems a director or officer guilty once a company commits an offence unless he proves otherwise. This imposes a legal burden on the accused. It is not merely evidential in nature. The court finds that such a provision removes the presumptions of innocence and relieves the prosecution of its burden. An accused person may be convicted not because the prosecution has proven its case, but because the accused has failed to discharge the burden imposed upon him. So this is fundamentally inconsistent with criminal justice. The court then considers whether such provision can be justified. While statutory presumption may be permissible, they must not undermine fundamental rights. In the present case, the burden imposed is excessive and unjustified. So the court further finds that the provision is overly broad. It applies to a wide category of persons regardless of their actual involvement. So this renders the provision disproportionate. So the court also considered Article 8 Clause 1, which is it is evident that not all directors were charged. This results in unequal treatment and violates the principle of equality before the law. So in light of all the above, the court concluded that Section 122 Clause 1 abrogates fundamental rights under Article 5 Clause 1, imposes an unjust burden and results in unequal treatment under Article 8 Clause 1. Accordingly, the court declares that Section 122 Clause 1 of the Security Industry Act 1983 is unconstitutional and void. So that is the decisions of this court. Court is adjourned.